Thanks.
Mr. Tipton.
Good morning. Larry Tipton for Mr. Seng. This case raises the issue of whether the Commonwealth is entitled to an independent examination by an expert of its own choosing on the sole issue of the competency of a defendant to stand trial. The Commonwealth filed a motion in response to the defendant raising this issue before the trial court because trial counsel, myself, had a serious concern about the competency of Mr. Seng. As we laid out in our brief, we're obligated to do that, both ethically and morally, to bring to the court's attention our concerns. I raise that because the Commonwealth's fundamental position seemed to be at the outset was based on our ethical duty to bring that to the court's attention. Somehow we waived the defendant's rights to object to an independent examination and triggered the independent examination. We don't believe that's so. Thereafter, the Commonwealth then moved to have its own expert examine the defendant for the sole issue of competency. And in that request, grafted onto it in their motion, as shown in the record appendix, that they expected us, the defense, to put on an expert to testify during a competency examination or hearing. We made no such predicate showing. We made no such averment. We never suggested at the least. Why? Because Bridgewater State Hospital had conducted a duly authorized examination. And as the court notes in its opinion, its ruling, he was found incompetent. Now, I filed under protective order the Bridgewater State Hospital report. So I will do my best not to make one reference to the contents except those that the judge, the trial court, laid out in her own ruling authorizing the examination. So
surely the judge, plain language of the statute, can appoint more than one examiner to do this.
You're quite right, Justice Court.
And if the judge gets one report and is not satisfied, or one of the parties is suggesting another report would be helpful, surely she has the discretion to say, okay, I'm going to have another examiner examine it. What's wrong with that under the statutory scheme?
Well, because under the statutory scheme, the judge doesn't have any authority to authorize a Commonwealth expert to examine and to conduct an examination that implicates his Fifth Amendment rights.
But once the judge appoints, I mean, the Commonwealth may recommend the examiner, but once the judge appoints the examiner, is the examiner the Commonwealth's examiner, or does the examiner file a report with the court and becomes another court examiner?
Well, the way that the order was written and suggested to the court and submitted to the court, it's clear from the reality of the situation that the Commonwealth is recommending an expert that it uses in its own cases, Malcolm Rogers, and that it is
he's a certified and he's certainly qualified to do it under the statute.
I have no problem with saying that Dr. Rogers is not qualified to conduct an examination. But
and where is the report going to go?
The report, if you follow the reasoning of Rule 14, the report will go to the court. But what they've done here is they've grafted on the Blaisdell reasoning in Rule 14, and ultimately that report could go, quote, to the Commonwealth's expert, Mr. Rogers, and be used by Dr. Rogers to testify against the defendant. And what occurs,
I'm sorry, which report?
The report that Dr. Rogers would issue pursuant to his examination
would go to the court.
Defendant.
Would go to the court, and then you said, and could be used by
the Commonwealth if they present him as their expert witness, which they intended to do.
Yes.
On the question of competency or on a question on the merits of the case?
Well, in the first instance, it would be competency, but that is the whole issue that raises by trying to graft on a Rule 14 and a Blaisdell reasoning to a competency evaluation. Rule 14 sets out a number of different things that have to be met.
Rule 14 by its terms pertains to the defense of lack of criminal responsibility because of mental disease or defect at the time of the alleged crime. I mean, Rule 14 by its terms, forget about what it sets out. It doesn't, by its terms, doesn't apply to competency.
And you're quite right, Chief Justice, and that's what we argue.
But the judge grafted the procedures on to ensure that the report would be adequately protected. Isn't that correct?
But it is correct. But it's correct insofar as we want to parse out what Rule 14 would apply in this context. But there's no direction from the court or from the Commonwealth as to what portions of Rule 14 do apply and what portions of Rule 14 don't apply. For instance,
what do you say? What portions should apply? Do you say?
Well, our
You
position.
don't want any to apply.
I don't want any of them to apply, Justice Speen, because what we're doing here, the second argument is an examination by an expert that's suggested by the Commonwealth and will ultimately be relied upon by the Commonwealth suggests that the defendant's Fifth Amendment rights are being implicated without any waiver.
If we don't agree with you on the second point, do you agree that the Blaisdell-type protections can be engrafted onto an order for a competency examination?
I don't think they can, because there seems to be, for instance, Blaisdell is predicated fundamentally on a waiver. Blaisdell goes through the Fifth Amendment rights and talks about the compulsion of a psychological examination, talks about the fact that Statute 233, Section 23B is not coextensive with the right against self-incrimination, and therefore it predicates the decision on waiver. There has been no waiver in this case.
Mr. Tipton, I don't want to suggest that anybody's playing with words because they have a very specific meaning. And I recognize that trial counsel in these circumstances are placed in a somewhat difficult position because you have an independent sua sponte obligation to raise competence. But so one could view it as saying the defendant, through the defendant's agent, his attorney, places his mental condition at issue. It may not be a waiver, but he places his mental condition at issue. Then when you combine that with our law, it needn't be the law, but it is the law, that it's the Commonwealth's burden to prove that the defendant is competent. The conceptual difficulty I have is what may a judge do? One thing a judge need not do, it seems to me, is to accept the view of one expert. Right?
Correct, Your Honor.
The judge is going to be faced with a particular problem where the Commonwealth says, Judge, and in particular you shouldn't accept that. In other words, it's one thing if the judge says, I'm not satisfied for myself, because the judge has an independent duty. I mean, this is not your typical situation if the judge believes that the defendant is not competent. The judge has a duty to proceed in a certain way, to make inquiry and to obtain. But we're not in that. I don't know whether or not Judge Quinlan was herself persuaded, because what the Commonwealth says is before you reach a conclusion, Judge, because it's my burden to prove that he's competent, at very least I should be able to select an expert in whom I have confidence. I'm not going to waive anything. I'm not going to ask you to, but the Commonwealth at least should have an opportunity to say, let me at least have an opportunity to see whether or not a well-qualified expert, so you can have a fight over, the qualifications, but an expert in whom I have confidence, either Commonwealth, says that this person is not competent to proceed to trial. Why is what Judge Quinlan did an abuse of her discretion, given our peculiar framework within, when I say peculiar, I don't mean to be negative, the framework within which we have asked all parties, trial counsel for the defendant, the judge, and the Commonwealth, to have certain responsibilities, but also to have certain burdens?
I'll attempt to answer those questions and just tell me I'm not doing a good job if I don't. First and foremost, you asked the question about waiver. When trial counsel like myself has to raise...
No, it's not waiver. Let's assume that I'll stipulate that it's not waiver.
Then
Well, I'll agree that it's not waiver.
But put in issue.
Put
It's
in
been
issue.
put in issue. whether it's a waiver or not, but it has been put in issue.
And under an ethical obligation, yes, it's been raised, as we must
Yes.
do. But there's no, but if the court is not seeing it as a waiver, then I will move on, because I would argue it's
No,
certainly not a waiver.
but the Commonwealth has an obligation to show that the defendant is competent. So presumably if the Commonwealth had reason to believe that a defendant was not competent to stand trial, the Commonwealth would draw that to the judge's attention. Now, you may say to me, that's highly hypothetical, but what I'm saying is right now, somebody, it could have been the judge, it happened to be defense counsel, we now have raised the question of the defendant's competence.
Okay. If the court is asking me to address the burden issue, that we all have responsibilities in this, that burden argument was rejected by this court in Commonwealth versus Brisson. The fact that the Commonwealth has the burden to prove that a petitioner is sexually dangerous does not give them the right under 123A to have that petitioner examined by the
But in those cases, the defendant isn't putting his mental status in issue. It's the Commonwealth that's putting his mental status in issue.
And once again, that's why I have to come back to this. The defendant himself was really not putting his competency at issue. The defendant wasn't. The defendant, that's why it kind of hinges on this idea of waiver. Any person can put, as the statute makes clear, 123, can raise this issue of competency at any time. So that, in and of itself, should trigger nothing. And certainly if a defendant is incompetent, as this defendant has been found thus far, if he's incompetent, he can waive nothing. So that's why I suggest that just by the mere fact of raising the issue of competency, whether it's raised by the district attorney, by the judge herself, or by defense counsel, or for that matter by a defendant over the objection of his defense counsel, it triggers nothing. The burden argument, the Commonwealth must meet its burden in a number of different situations.
Well, let me just interrupt you for a minute. Just assuming for the sake of argument that we don't agree with you, and that we say that the defendant has, in fact, put his mental status in issue, what kinds of restrictions should be imposed upon an order, or conditions, restrictions or conditions should be imposed upon an order for an examination by a Commonwealth psychiatrist?
The only possible restriction could be a complete immunity from any and all statements that are made during that examination, that no statement, no fact, nothing can be used at any hearing outside a hearing on competency. And that is not what the law is right now, and that's certainly not the protection afforded by 233.23b.
Or Rule 14.
Or Rule 14.
Mr. Tipton, just so that I understand, between the statute, the rule, and the gloss that Blaisdell has put on it, which is not only the statement can't be used in evidence, but essentially it adds on the fruit of the tree of the statement. Anything that flows from the statement can be used. You're saying even that is not sufficient. You have to have complete immunity.
Yes, Your Honor. And the cases that the Commonwealth tends to rely on, and the case that was cited in Blaisdell, in the one paragraph that they rely on, People versus English,
right,
as it's cited, when you read that case, it's clearly laid out that as for statements made during a competency evaluation, there is complete judicial immunity. Same way with Backley, the California case that the Commonwealth relies upon. The Backley California Penal Code required complete immunity as it applied to any statements made during a competency evaluation to anyone.
Well, are you suggesting, first of all, that this would, in fact, limit the judge's ability to compel your client to undergo any examination?
Well, Justice Cordy,
forget about the Commonwealth's expert, any examination.
Justice Cordy, I am suggesting that in the context of my Sixth Amendment argument in the third part of our brief, and it follows this way. We don't want a policy where defense counsel tells their client, okay, now you can't even go to Bridgewater for a duly court-ordered 15A or 15B evaluation because I can't tell you how your statements may or may not be used. And if the Commonwealth comes forth and they say they can examine you with their own expert, I'm going to advise you not to cooperate. That seems to me to be setting up a precedent where we know what due process requires. A defendant must be competent to be tried. And now we're setting up a situation and a procedure where defense counsel may be compelled to tell his or her client, don't cooperate with the competency evaluation.
Well, first of all, if the defendant is not competent, it's not even clear to me that the defendant could understand. The whole point is the defendant couldn't understand what, I mean, you may say, don't cooperate. What does that mean to a non-competent defendant?
You're absolutely right, Chief Justice Marshall, and that's one of the arguments we make in Part 3. As opposed to giving advice to someone in the context of a criminal responsibility examination.
Well, that's different.
Once we've raised it, but we're not dealing with an incompetent defendant. Here, we're dealing with a defendant who may or may not be incompetent in the first instance. Right now, we have a preliminary finding by Bridgewater State Hospital that he is. And I think it's important to point out that while the Commonwealth says that an inquiry into this competency issue will not raise issues as to what happened at this criminal event, that's quite the contrary when you read the whole content of Dr. Holton's report.
Well, in any event, I mean, I could without even, I don't know what happened and I haven't read the entire report here, but I can certainly imagine, particularly somebody who may not be competent, may well say something, not because the expert is trying to solicit information, but information could well be forthcoming during the course of that interview, even if the expert is trying very hard to focus only on the present and not ask anything about what happened at the time of the incidents.
If I could just end by saying this, the burden argument also doesn't apply. It shouldn't be the force because of the ruling in Prasant, but also because of the reasoning of Rule 14. The Commonwealth may have to bear its burden on criminal responsibility if there is no notice of an expert relying on the statements. So this burden argument should not carry the day when it comes to the determination of competency, even though the Commonwealth bears the burden. And I would rely on the rest of my brief that my time is up.
Thank you, Mr. Tipton. Ms. Smith?
Assistant District Attorney Loretta Smith for Middlesex. This Court has repeatedly recognized the importance of more than one psychological, psychiatric witness when it comes to issues dealing with state of mind, intent, voluntariness, and it is really no different with competency. Competency is a slightly different legal determination, but yet one based on psychiatric diagnoses and opinion. This statute dealing with competency, unlike the SDP statute, does not limit the number of examiners the Court can appoint. It clearly says that the Court has jurisdiction to appoint one or more qualified examiners. There is no issue that Dr. Rogers is not a qualified examiner.
Ms. Smith, this is unlike, you are correct, that what is at issue here, in a sense, has to do with how everyone likes to phrase it, the defendant's mental capacity, his, the questions are slightly different. But what is the Commonwealth's objection, if any? And I really ask the question as an attempt to assist the Court of granting in a competency determination, which is not the factual, that's just right now, because as we know, the fact that that a judge concludes that a defendant is not competent right now says nothing about next week or the week after. We have an unusual situation here. We've already been through one trial, so in a sense we know what the defendant, what the Commonwealth's best evidence was, at least first go-around. What's the Commonwealth's objection to granting complete immunity to the defendant in any of these statements made, assuming that we agree with you that under the statute the judge is free to appoint an additional expert?
I think actually that's what Judge Quinlan was attempting to do.
Well, she was attempting, but let's assume that we think that wasn't, not faulting Judge Quinlan, but that the combination of Blaisdell and Rule 14, and Rule 14, it's because it goes to a different question, I think, puts limitations on which may not be adequate here. So the Commonwealth would have no objection if it were complete immunity?
Well, it depends what complete immunity means.
I was just going to ask that question. Thank you, Judge Cordy.
If you're talking about use immunity, that's one thing. If you're talking about immunity for any crimes that come up in the course of the conversation, I assume the Commonwealth would not agree to that.
No. I took Mr. Tipton, and maybe I'm wrong, of using use immunity. From any and all use of statements was his. And Mr. Tipton, you can, I'm not going to put words into your.
I think what Judge Quinlan did by engrafting the procedures from Rule 14, and obviously we have the statute as well, the Commonwealth could not use any statements about this crime that came up in a competency hearing.
What about a new crime?
Well, the statement's sealed. The report is sealed.
No,
Is
but
that
what
correct?
about, I mean, that then goes to, what about a new crime?
If something is said during the competency hearing that would incriminate the defendant, I think the whole point of the Rule 14 protections is that we don't have that information. I mean, it says that basically what the judge is supposed to do when she gets the report, if there is anything that violates the privilege against self-incrimination, that is not to be disclosed to the Commonwealth. And in fact, the rule goes to say if the information can be, the privileged information removed, then the report can go that way.
And if it's improperly disclosed to the Commonwealth?
I don't understand that. That
I mean,
should
you
not
don't
happen.
understand. Yes, it could. I mean, the report could go to the doctor. The doctor files the report
Well, the
with
doctor
the clerk.
files the report.
The clerk doesn't give it to the judge, and it never gets redacted, and the clerk just passes it along to the prosecutor.
We can't
that
use
has
that.
happened
We can't use that.
for anything.
I believe
Okay.
that is the intent of the rule, that we could not use it for incriminating.
So the distinction that you were recognizing in Justice Cordy's question is if this defendant happens to talk in some respect about the incidents that underlie this indictment,
We clearly,
the Commonwealth can proceed. I mean, tell me what the distinction is that you're trying to have me understand when I say, what's the problem with granting immunity?
I believe that anything that would violate his privilege against self-incrimination is something we should not have, and if that's what you mean by full immunity.
I'm asking you to tell me. You're writing the opinion
All right.
in the strongest possible terms.
Anything that would violate the defendant's privilege against self-incrimination in this crime or any other crime that might appear is something that the Commonwealth cannot use against the defendant to, in determining guilt or innocence. It may be able to use it as dealing with competency if it so reflected on his mental condition, but
Explain to me, if you would, the process, the normal process here. Judge or defense counsel recognizes that competency may be an issue. The judge orders a report under Section 15, or is it 15 or 15A? 15A. Where does the report ordinarily go, leaving Rule 14 aside?
all right, I think the normal situation is a situation which is not this case, where the defendant's competency is raised and the court clinician that works for the court
This
comes
is
in.
usually before there's been a trial, correct?
Correct. And evaluates the defendant and then gives an opinion to the judge as to whether or not the defendant is competent.
That goes to the judge only, a report or an oral report or a written report to the judge only?
I think in the first instance it goes to the judge, but that is the knowledge. I mean, the Commonwealth knows and the defendant knows that the court clinician has determined that there's a question about the defendant's competency.
Then what happens?
Well, then you go,
Assuming the judge says there's evidence of lack of competency, then what happens?
then you go to Section 15B, which in this case was a referral to Bridgewater because the defendant was incarcerated and met the requirements of being transferred to Bridgewater.
For an evaluation?
For an evaluation to take place within 20 days, and if the 20 days is not sufficient, then they apply to the court for an additional 20 days. So within that 40-day period, they're to make an evaluation, which includes a report which goes back to the court.
And did that report go only to the court?
No, in this instance, it went to all of us.
Well, ordinarily, the report coming back from Bridgewater, which is really the report of the mental examination of this person for competency, does that just go to the court?
I think in the first instance, it goes to the court, but I would expect that the normal, and I'm sorry, I can't tell you this is exactly right, but that in the normal course, both the defense counsel and the Commonwealth would get a copy of the report.
So, and that's what happened in this case. Everybody got a copy of the first report.
Correct.
Then the Commonwealth says, we'd like another examiner appointed to conduct another evaluation.
That's correct.
And the judge said, fine, but I'm going to engraft the Rule 14 procedures onto it. Is that right?
Correct.
But those procedures wouldn't ordinarily, neither those procedures or anything like those procedures wouldn't ordinarily govern how this report is distributed and used?
I have to confess, I'm more an appellate lawyer than a trial lawyer.
Okay,
I don't know the answer to your
no,
question.
I'm just wondering, if the regular report, the one that you got, the one that everybody got, comes back and has a lot of surprisingly incriminating stuff in there, even though it's focused on today's competency, not yesterday's crime, for whatever reason, the conversation and the discussion goes on and it's included in this report, what happens?
Well, I guess in a sense that is the case with the first report. In this instance, when he was referred to Bridgewater, there was no Rule 14 procedures engrafted on that report. This report does not contain anything that appears violative of the Fifth Amendment. It's really an analysis of his present functioning and his course of treatment over the years.
All right, so that's what happened here. But there's no protection, as far as you know, ordinarily in this report, if in fact it did contain information.
Well, there's a statute basically that governs the use of information from evaluations under 15 and 16, and that's.
Ms. Smith, with one of the claims that the defendant makes here is that when you talk about the first part of what might typically arise with a court clinician and examiners flowing therefrom, that they function under the recommendations of the Department of Mental Health, designated forensic professionals training and certificate, that you try to avoid asking questions. With the Commonwealth having any objection that those were also grafted on, which of course are not part of the statute, are not part of Rule 14. In other words, I think the defendant has an additional concern, which is now you've got the Commonwealth's expert. I mean, the use of the term Commonwealth is a little odd in this context because Bridgewater is the Commonwealth, as is a court clinician is the Commonwealth. But I take it that let's assume for purposes of this discussion only, I'm talking about the prosecution's expert. Essentially what the defendant is saying, there are no limitations being placed on what the prosecution's expert can ask the defendant. Should there be limitations?
Not that I believe this Court should impose, no. I mean, he has Dr. Rogers, as well as any other qualified physician or psychiatrist who is qualified to make such a competency evaluation. They have ethical norms. Why would...
Because because the Department of Mental Health designated forensic professionals, as I understand it, I'm just looking at the defendant's brief here, says when you're making a competency determination because of the very important issues at stake here, examiners should ask a defendant to give an account of the alleged offense only when this information is necessary to order. Now, if you don't tell Dr. Rogers that that's one of the limitations that should pertain, why would he not, for some reason, ask whatever he wants to ask? I mean, I think that there's a concern here that somehow if the Commonwealth's prosecution team has retained an expert, that the competency evaluation itself will be, not talking about the qualifications, will be conducted in a way which is different from one that flows from a court, the procedure you just outlined to Justice Cordy before, the court clinician, then you send them down to Bridgewater, where they specifically know what you're doing with respect to competency. You could, for example, select an expert who had never testified for the Commonwealth before, had never been asked to do this before, and your only instruction is tell me whether this man is competent to stand trial. Right?
Well, the court is to instruct the examiners, it says right in the statute 15, section 15, on the standard of competency. So there is some court involvement in instructing the examiners as to what their standard is that they're to look at. If you're saying, should we also say to the court, and you must tell the psychiatrist to follow the guidelines of the Department of Mental Health, I would expect that people who are qualified to make these forensic evaluations are familiar with the guidelines.
They may or may not be. Why? If somebody hasn't been involved in this before, why would he or she be?
I think probably to become qualified to do it, you would need to be aware of the ethical. To do a forensic evaluation, you would need to be aware of the guidelines from any
Forensic
department.
evaluation for what, though? This may be the highly qualified expert's first request to determine the competency to stand trial, and the judge, gives some, says, this is what we're looking at. Does this person appreciate that, whatever it is, that's the standard? It doesn't tell you how to go about it. And one thing that this person says, well, if I get this person to tell me what the underlying offense is, I'll have a much better way of understanding whether today he appreciates anything.
Well, perhaps it would be wise then for the Superior Court, when they instruct with the examiners as to what their task is and what they're to find, to give them a copy of the guidelines.
Ms. Smith, and again, I'm not asking you to make concessions, on behalf of the Commonwealth. Why would it not be appropriate for the Commonwealth to say, I have received, the court has received, defense counsel has received the view of one expert, qualified expert, we don't question that. But this is a determination that has extremely serious consequences for the Commonwealth. Apart from anything else, if this defendant is not competent to stand trial now, it may be some time, witnesses disappear, evidence becomes stale. These are extremely serious consequences for the Commonwealth. We are not prepared to rest on the professional conclusion of one expert. We would like the court to appoint a second expert. Not the Commonwealth's expert, a second expert. The Commonwealth would like to submit some names, but the court might have some names itself, and this will not function as a Commonwealth's expert, it will be a second expert. What is the problem with that?
It seems to me that that would be within the discretion of the trial judge. The statute does give the trial judge the discretion to appoint one or more, and it would be up to the trial judge to determine who to appoint. We asked for a particular examiner, and within her discretion, she granted our motion.
So what you're saying is the procedure followed here was in effect what the Chief Justice was suggesting. Is that
I
what
think
you're saying?
what Justice Marshall was suggesting, that the court
Well,
would appoint a second examiner, but not one that we chose.
You could submit a name. My question is, all of the papers, the judge's order says the Commonwealth's expert, and certain things flow from being the Commonwealth's expert. One is the Commonwealth, as opposed to a neutral, independent expert. I'm not saying that the Commonwealth is doing anything incorrect, but the Commonwealth obviously has an opportunity to talk to the expert in a way that the Commonwealth didn't have an opportunity to do at Bridgewater, for example, right? You didn't sit down with the expert at Bridgewater and say, I want you to look at this, you should inquire about this, whatever it is. The Commonwealth, it wasn't the Commonwealth's expert. It wasn't the Commonwealth prosecution team's expert. It was the government's attempt to determine whether this person was competent. Not unreasonable for the Commonwealth to say, I'm not prepared to rest on one expert. I think there should be another Bridgewater type. If there's a second person who says that this man is not competent, that would be helpful to the Commonwealth and to the court. But why does it become the Commonwealth's expert?
I think the nomenclature, Commonwealth's expert, is that we have chosen someone that we have confidence in to do an evaluation. We've chosen that person for a reason, because we do have confidence in that person's skills. So, yes, he's our expert in the sense that we asked for him to be appointed. I don't think he's an expert in the partisan sense. I mean, competency is a precondition to trying any defendant. We want a determination from someone that we have confidence in that this defendant is competent or is not competent. And he's a Commonwealth's expert only in that sense, that we have chosen someone with whom we have confidence. I don't really see the competency hearing that would then take place as being as partisan as other kinds of issues.
How do you respond to Mr. Tipton's interesting point, I thought, that the Commonwealth is entitled to examine, in this sense, the Commonwealth is entitled to examine a defendant when there's a Rule 14 issue, only when the defendant is going to have its own expert testimony. The defendant is going to have his or her own expert testify. Otherwise, one just goes to trial. The Commonwealth doesn't get a right to examine the defendant.
That's correct.
Even though the Commonwealth has the burden, very high burden in those cases, beyond a reasonable doubt burden.
That's correct.
So why should the Commonwealth get it in these circumstances?
Well, because it's a different scheme. I mean, the statute gives the judge discretion to appoint one or more examiners.
No, I understand she can appoint one or more examiners, but much of what the judge's decision rests on seems to me that the Commonwealth has the burden.
She mentioned that. She also mentioned that it was not unusual to have an expert chosen by the Commonwealth appointed to do a competency exam. The fact that we have the burden actually does argue in favor, it seems to me, of appointing a Commonwealth-chosen expert. It certainly doesn't argue against it. And I think it does support the judge's exercise of discretion. We have to prove, not beyond a reasonable doubt, by a preponderance of the evidence, that the defendant is competent. And one piece of the evidence at the competency hearing will be the Bridgewater report. One other piece will be Dr. Rogers' opinion. Other pieces will be the defendant himself, the court's observations. I mean, it's giving the court more information, and information that is necessary to make a determination. If you look at, in this particular case, if you look at the report that in fact was generated by the clinician at Bridgewater, it's not a very definitive report. It shows that, and this is what's quoted in Judge Quinlan's opinion, that this examiner had difficulty talking to the defendant about his defense. The defense that this defendant knows all too well because he's seen it play out in his first trial.
That doesn't help if he's not competent.
Thank you very much.
I just have one question. When an examination is ordered on the question of criminal responsibility, we all focus on incriminating statements the defendant might make because we already know at that point what the defense is. The defense is lack of criminal responsibility. But in the case of an examination for competency, we don't know what the defense is, and the psychiatrist is going to be examining the defendant on whether or not he can assist in his defense. And the defendant may be making statements that are not necessarily incriminatory, but could be revelatory as to what the defense is that the Commonwealth might otherwise learn about. We've talked about use immunity, but are there any other kinds of statements that the defendant might make to the psychiatrist that should not be exposed to the Commonwealth?
Yes, I suppose a defendant who revealed his lawyer's work product by blurting out something that he shouldn't have blurted out.
His defense.
His
defense.
All right, usually that's not a mystery, but let's say he did. He blurted out something that is protected by the attorney-client privilege, and he did so because he was incompetent. Not a waiver of his own privilege.
Well, he's not incompetent. The psychiatrist comes back and says he's not incompetent for these reasons. He understands what his defense is. Here's what they're planning to do. And
This is the order. They've had a discussion about the order. They have a discussion about whether or not he'll take the stand. They've had a discussion about whether they should cross-examine the victim's, the child vigorously. And he was fully informed as to all of those, and I therefore conclude that he is not incompetent.
I think what the examiner is attempting to find out is, can the defendant assist his attorney?
That's right, and he's saying, I asked him about whether he has any views on the order that the witnesses are called. I asked his views about whether he understands that you can cross-examine, but you don't have to, that he can't, all of those, that's what you're asking.
I don't think that is what you're asking. I think what you're asking is, can he weigh advice? Can he listen to his lawyer? Can he provide factual information in the case about what happened? Can he communicate?
How can he ascertain that without giving him an opportunity to say, give me an example? I'm not suggesting the expert is doing anything wrong. But if the expert is simply talking to him about, do you know where the Red Sox are? I hope. This examination wouldn't take place today.
I take it this is a problem.
I really don't mean to be, but you understand. The question is not, does he understand what day it is, what country he's in? Quite the contrary. It's a quite specific inquiry. It's not...
But I take it this would be a problem even on a court order examination.
Yes.
This isn't a problem that would just be confined to an examination by a Commonwealth recommended expert. This would be a problem on any 15A examination.
It would be a problem on the examination that he's already had at Bridgewater.
Exactly. And I take it that at least with respect to the judge engrafting Rule 14 onto this, it provides an extra layer of protection for the defendant, because the Commonwealth is not going to get this report, and if it gets this report, only after the judge has reviewed it and excluded anything that might be inculpatory.
That's correct. If we get a report, it is one that is sanitized of anything that was violative of the Fifth Amendment privilege. And I would presume, even though Rule 14 doesn't deal with this, if there was attorney-client material that was in that report that was privileged, the judge would excise that as well. Superior Court judges are charged with that responsibility. Thank you very much.
Thank you.